Society of Chartered Surveyors, who's hopefully going to provide some insight into what has been a fairly difficult process.
Right, thank you very much. Chair, delighted to be here. Always I've been served on a regional committee for 12 years myself, and certainly will always be available to any of the regions to support them in any format that they need me. Just conscious that just of the time, and so just to make you aware, I understand that that this session, the idea of this session was that I would give a brief update and then open up to the floor for questions and answers. I suppose I'm conscious of it also being videoed. So just that if there are issues in the room that people don't want to raise, I'm here for the whole day, and I'm willing to either meet a smaller group or meet individuals. So just seek me out if you do want to talk further. Following on from Ciara's presentation, and as the Chair has outlined, my role as Director of Regulation is that 50% of the membership are subject to statutory regulation now by the Property Services Regulatory Authority. My first experience of the Act would be from August 2010 onwards. Without saying it in a personal way, certainly every piece of information that I was given from that time wasn't the case. Things that I was told were ready to go and be rolled out, and I took assurances for that, were not ready to go and were not ready to be rolled out. So what I want to do today is, the last time I met the regulator was last Thursday afternoon, so I'm literally as current as I can be. I don't think I have all the answers for you, but certainly I'll give you the answers that I do have, and between us we'll figure out the stuff that we don't know. So I'm just going to step back for a moment, and I'm going to take you back to that period in August 2010, and what is this all about? And we constantly refer to these presentations that it's all about the public interest, and what does that actually mean? Now, there is no definition either globally or locally as to what is the public interest. So the best that I can come up with is that Mr. Justice Kevin Cross was appointed to the High Court bench last year, and he was the advisor to the Irish Medical Council. So complaints of misconduct or poor professional performance against a doctor or a surgeon, he would have been the legal advisors in that process. He has, because he has become a judge, has actually started to write a lot of his opinions that he felt he couldn't before as a legal advisor. And this is one of the issues he's addressed, is what is the public interest? And he has actually changed that question that I've put up at the top of the screen, is that all the time we must be looking at the fact we're serving the public interest, where we're constantly asking the question, how can the public best be served? So he distills it then into the regulatory pyramid, and that starts with the substantial base of that you establish somebody's competence, in this case a licence. And that's the first issue that has caused everybody in this room a lot of difficulties in the last 12 months, is the fact that the professional qualification wasn't recognised by the PSRA. Now, the reason for that was the PSRA adopted an approach that they wanted to establish that somebody had a licence previously, and they very much liked the idea of the fact that somebody established their competence because they had a licence previously. Now, I certainly endorse that, and I know that there would have been people in the room where I said, rely on your licence. And you would have been pointing out to me, yes, but they're not recognising the qualification, and that would be true. And I wasn't trying to devalue the professional qualification. I was looking for the path of least resistance to get your licence into your back pocket. They had €1,000 of your money, you didn't have your licence. So those of you who heard feedback from me saying, rely on your previous licence, that was the reason I did it. In the meantime, the PSRA has acknowledged that the professional qualification is in place and that they do now recognise it. Admittedly, they're relying on us using their discretionary powers, which they were very reluctant to do at the start. They did not want to start using the words discretionary powers. They wanted a kind of a black and white issue. You had a licence previously and we're now giving you a licence. That's the way they wanted to approach. It took us several months to point out to them that they had discretionary powers, which they had anyway. But they are now starting to exercise those discretionary powers. But they keep reminding every presentation that we have with them, or every engagement we have with them, is, but the majority of our members had a licence anyway. So that's the point that they would make. That moves on then to, once competence is established, you have your licence, you maintain your competence with what we refer to as CPD. Under the Act it's referred to as maintaining your competence. Again, the authority have not entered into that area at all yet. The reason being that they are solely focused on the application process at the moment. And I have statistics later on for you with the application process. But the point that I'm making here is the fact that the mandate that the authority have for CPD, they have not started working on it yet. They have ideas, but certainly nothing substantial. The whole issue of customer care, there is a code of practice published by the PSRA website, and the way you establish misconduct of somebody is you measure them against their code of conduct, code of practice in this case. The code of practice that's been published by the PSRA is out of date, and the regulator tells me that they are looking at getting it updated. For example, it refers to the fact of the former legislation, would be one very obvious error. I'm going to deal substantially with letters of engagement in the next part of this presentation. And again, the regulator on Thursday was reinforcing the Act that he very much saw the whole issue of customer care was flowing from the fact that you had a licence to do something and that you had a contract with a client. And that if that client became dissatisfied, you had an internal complaints handling procedure. Now again, the authority has done their focus to date has been on the whole application process, but they do have a mandate in raising awareness on those issues. Ultimately, you all have PI cover in place, and that's the example of that if you are negligent, a member of the general public is protected because if there is loss there is insurance to cover it. Similarly, in cases of dishonesty, that there is now a statutory compensation fund in place. The regulator last Thursday in Navan spent a lot of time explaining about the fact, and I couldn't establish why he was drawing this distinction, but it wasn't just cases of dishonesty, it was any loss by a member of the general public is subject to the compensation fund. I'm speculating here, but they are very strong on the fact that they want to start stepping into the shoes of people who they perceive as either being subject of poor professional performance, and they, similar to the way that an insurance company when it pays out looks to step into the shoes of the claimant, that seems to be where they're going. So I would always refer to as compensation regarding dishonesty. Certainly the regulators seeing his remit as being for more than that. Again, the Act provides for mediation. How I define that is very much that an interpersonal dispute continues. In other words, under the complaint handling procedure, if you're still not satisfied with the answer that you're getting from the managing director of the franchise, that there is a mechanism there where you can go to a form of mediation, which I see as resolving an interpersonal dispute. And then ultimately it leads to the fact that the authority has significant powers of investigation, up and including entering a family home and seizing documents, which are very substantial powers, and ultimately always the one which attacks your constitutional and your human rights, which is that it removes you from a profession. It removes your ability to make a livelihood, and the authority do have the powers to remove a licence. But that's why it appears at the top of the regulation pyramid. It is an extremely onerous task to remove somebody from a profession. So what I want to convey by that is I would like you to see me that threatening you in any way or something like that we're coming to get you, because that's important, is that there is a substantial, when everything else is in place, there is no requirement to remove somebody from the profession, because the public is protected with the fact that if you've been negligent, even if it's unintentional, there is insurance there to cover the loss. If there's dishonesty, there is compensation there to cover the loss. If you continue to feel bad about the whole process, there's a format of mediation. So if all those things are in place, that is what the Property Services Regulation Act sets to achieve, and it's the same as every other statutory form of regulation. It's the same as every other form of self-regulation in the global context, is that statutory pyramid. Just to draw a couple of things, Director General referred in the earlier presentation to the fact that the statutory regulation of quantity and building surveyors rolled out relatively smoothly compared to what happened with the property services providers. And the main issue is this one here, is quantity and building surveyors don't hold client money. When you don't hold somebody else's money in trust, you drop way, way down on the risk factors with the regulators. In fact, the only risk factor that's higher than holding somebody else's money is the fact of medically incapacitating somebody and ultimately medically killing somebody are the only two higher risk thresholds when it comes to regulation. And hence, why does the registration body for building and quantity surveyors don't have the power to enter premises and the PSRA do? That is the reason, it's client money. So if that's the overview, I suppose the point that I'm making here is regulator used terminology in Navan last Thursday of last year was for licensing and this year is going to be for regulation. You've possibly heard me say in other formats that this isn't going to be a sprint, this is going to be a marathon. I think I'm going to be giving PSRA updates for the next 5 years, and I think every time I'm going to be giving it, we're going to be talking about where it falls on that pyramid. So I'm going to start focusing in on various items. The first one for me, by far the most important thing, if I am worried about things at the moment, it's certainly coming to client money. I've stressed in this format before that that is not based on the fact that any of the practitioners in this room, that there is any statistics or anything of that nature of dishonesty among the membership. I openly acknowledge that the membership up to this point in time, and will continue to do so, always operated to the highest principles. Their client accounts were always in place. The headlines that you can Google are not about property services providers or chartered surveyors. They are about other professions, and I certainly reassure you that I get that. The reason I'm talking about client money is because on a regulatory framework, holding client money moves you up to the risk factor, and therefore it will always bring you to the attention of a regulator. The issue that's there, and certainly when I met the chair of the authority first, it was the risk factor associated with client money. But to be fair to her, her experience was informed with the fact that she had solicitors on her book with, significant sums of money missing out of client accounts. So that's what's informing her position. It was the first aspect of the CPD programme on the new regulations, and it is still available on the Society's website, is the aspect of the new client money regulations. They're significantly based on the solicitor regulations, and you will see in that presentation the fact that the solicitors regulations are now 11 years in place, and therefore there's 11 years of learning with what has happened, and we're still starting new. So certainly, and similarly, there's a follow-up article in the journal, and I have copies of it here, of Show Me the Money. It asks the 6 key questions. To me, and I'm not a practitioner as you know, but certainly the whole aspect of the partnership between the principal officer, i.e. the person who owns the business, the legal entity, the bookkeeper and the accountant. Even as recent as last Thursday, members were saying to me, Brian, I don't know why you're worried about client money, sure the accountant will look after that. I have a very good bookkeeper, we've never had a problem with them. What they're missing is the key aspect of the principal officer with a major license application. The principal officer and the accountant signed a declaration that it was their intention to put the client money regulations in place. When you go for the renewal of your license, you as principal officer is declaring that they are in place. You're making a declaration. And similarly, the accountant is making a declaration that everything complies with that. He is confirming your declaration. And certainly I'm concerned with the fact that the accountant's report and the accountant's process for the renewal of your license is not yet published. And similarly, I asked the regulator, and I did not get a clear answer to it last Thursday, was what accounting period are you talking about when someone goes to renew their license? Now, and I'm not being smart here, I asked 3 times, and 3 times I was told that it was the accounting period. And I was going, is that the 5th of July, Is it the 1st of December? You know, is it the 1st of January? Well, what is the accounting period that you're right? And that is not clear. Outside the room, I also asked the question and I asked for follow-up on your behalf. So certainly the next issue that I need to have resolved is the whole issue of client money and the renewal of your licence, and the process that your accountant is expected to use, and the report that your accountant is expected to sign. Letters of engagement. I've had a lot of queries on letters of engagement, and I'm really glad to be standing here having seen that presentation last Thursday with the regulator. The regulator, from what I can see, and I'm not making personal comments here, but certainly when I'm listening to the answers of questions, it's like pendulum swinging. We are there to help people, but by, God help you if you don't do it. I have significant powers of sanctions. So, and certainly this is happening with the letters of engagement, because the feedback that I was given with the letters, the regulator last Thursday said letters of engagement are in place since the 5th of July. Now, the letters of engagement weren't published till the end of September, so how you get a letter of engagement from the 5th of July? The next issue was, initially the letters of engagement that were published on the website was, and these were the letters that are currently on the website. The initial guidance was that these were templates, but that doesn't now seem to be the case, and I just revert back to what the legislation actually says. Basically, you shall have a license. A license holder shall have a contract with a client. That's basically what it says. Can you provide the service if you don't have a letter of engagement? No, you can't. There is no softly approach with the letters of engagement from the regulator. You will sign letters of engagement, and he wants a letter of engagement with every client that you have, on every client matter. Now, the regulator isn't a property service provider himself, and part of the confusion that has happened for the membership is when you ask somebody in Navan, you're now talking to a property service provider, so you're never going to get a satisfactory answer from somebody who isn't a property person themselves. So the issue here is that they now seem to be quite clear that you'll have a letter of engagement, but they're still not clear on the difficulties that practitioners are having. That's another observation that I would make, is that the letters of engagement are affecting every practitioner differently depending on their business. The same process happened with the application process. One of the issues was, why didn't the society issue general overall guidance on the application process? They couldn't, because I've seen them. I've seen over 900 of them. Every letter that came back to a practitioner was different. Every single letter. There wasn't a trend, there wasn't a pattern. Literally every single letter would be coming from a different perspective, whether you were the employer, whether you were the employee, whether it was qualification, etc., etc. And similarly, the letters of engagement are affecting every practitioner differently. Some of them apply to auctioning cattle in rural Ireland, and some of them apply to letters of engagement to auctioning painting on the wall, which are property services or services that have no relationship to letting an apartment in Galway city centre. So the most important thing to say about legislation or the letters of engagement is the fact that the regulator, and this was the first time I realised this, is seeing it that the letter of engagement or the contract with the client will have the same status as the contract for sale of the property itself, was the example that he gave. Now, speaking personally, my engagement with a property service provider was always separate to the fact of when the transaction was agreed, and then it moved into the legal process where the solicitors were talking to each other. Certainly the regulator last Thursday was very clearly stating that, well, if you're going to your solicitor to conclude the sale anyway, you should be going to your solicitor with a letter of engagement. And it's one of the questions, and it's one of the issues of, well, these letters of engagement, when we tell somebody they have to sign them, and in fact I can't provide the service unless you have signed it. One of the questions back is, but sure, somebody will need to go to a solicitor on this, and the regulator is saying, yeah, And that's why they're given the 7-day grace period beforehand, is to give them time to go out. So I just repeat that what I'm saying is that traditionally letters of engagement, certainly from my perspective, was never seen in that status. Whereas the regulator is certainly saying no, he does want it seen in that status. That the contract for the sale of the property will be as equal to the contract that you'll sign with the property service provider. I've dealt with the fact that they've been there. Again, I have copies of the article terms of engagement that appeared in the journal. For me, he wants the express contract terms very clearly set out. The famous one, it's 19 pages long. Yes, he wants 19 pages long, and he wants the minute dealt with in the contract. Can I make changes? Originally, we were told the letters of engagement that appear on the website in September were a template, and they were not a specified form under the primary legislation. He is now quite clearly stating that they are the specified forms of the primary legislation. You cannot make changes to them other than the areas that he has indicated. He is prepared to listen to individuals who said that they want to make changes once they clearly show to him that it doesn't affect what's written in the primary legislation. And the example that I would give you is the fact that the VAT rate that's quoted, he's prepared to change the insert for the VAT rate, because when the transaction actually happens, the contract and the letter of engagement, that a new Finance Act may actually change the VAT rate that's applicable at the time of the transaction. So he's willing to look at that, but that's the level that he's willing to look at change. And as I said, that is last Thursday, so this is straight, this is as up to date as it gets. Certainly what I would be advising members is, from the point of view of letters of engagement, they won't be an issue until there's a problem. When a complaint is made against you, and I think there will be, because there will be, we all, I have them in my life, you have them in your working lives. All you need is the one individual who's the type who will make a complaint. And immediately they're off to a winning start, however unfair the complaint is, when they can say, well, I don't have a letter of engagement, or my letter of engagement doesn't match what's on the PSRA website. So, but to remember also that when it is 19 pages long, is to what I know a lot of members are doing, is in the cover note to the 19 pages. They're pointing out to their clients that, and as I've described it here as a shield, they've pointed out the fact that this is a statutory regulator has put this in place. They are not the ones looking for this to be put in place, that this is coming from somewhere else. And it's very important that you do protect yourself in this process. And the more I read them, the more I see the letters of engagement being a shield. That I get when people are saying to me from a common sense point of view that I can't get people to sign a 19-page document, but I think you need to protect your interests. Other issues, letter of engagements, again from last Thursday, was the fact, well, when somebody says, I'm going to take my business down the street, I'm not signing your 19-page document, I'm taking my business down the street. And the regulator quite clearly stated that, send that individual on to me, that client on to me, and I'll tell them that they can't sell their house, they can't let their apartment, and they can't sell their paint. Because there is no business down the street who's going to provide a property service without a letter of engagement. And very much what he was saying there was, we would all stick together now as a marketplace. That's very much was just to spend not to spend a whole lot of time with compliance, but I think it's important in an update to just reflect where we have been, because I certainly know things now that I didn't know then. The road that we've travelled. The legislation came through the Oireachtas in the winter of 2011. It was the first piece of legislation signed by President Higgins on the 20th of December 2011. It then passed to the Minister. Certainly at that point, we were given a lot of reassurances that, we had been 4 years, we had looked at a lot of the detail, everything was ready to be rolled out. The reason it couldn't be put in the public domain was the actual authority itself wasn't appointed. But when they had seen all this documentation, it would come out very, very quickly, in loads of time for the 5th of July deadline. The authority was appointed in April, looked at the new regulations, passed them to the Minister. There was a technical issue of them coming back to the Oireachtas, and then ready for public issue. I can honestly say everything wasn't published till the middle of June. So people literally had a 2-week lead-in. I mean, the accountants' reports weren't published till the middle of June. They were, you had to have them signed in a 2-week period. That's the road we've travelled, I suppose. In that, when we were reassured that things were ready to go, I think that's important when we're being told that things are ready to go now, that we have that context. The stats is there was 5,000 applications, 3,900 of them have been processed. The regulator is openly saying that he has refused 100 licences. Again, this is important about terminology. He hasn't actually refused 100 licences. What has happened is that there has been 100 incomplete applications. In other words, somebody has put in an application and they're saying, we don't have a client account and we are never going to have a client account. We don't have PI cover and we are never going to have PI cover. And in the eyes of the statutory regulator, that's an incomplete application. So when he's saying that he's refusing people, he isn't actually refusing people. It's just that there's 100 incomplete applications. He's telling us that there are 300 1,000 licences actually in people's hands. Can I just do a show of hands if that's okay? People physically have their license in their back pocket? Certainly the majority of people, yeah. There is no appeal before the appeals board. And then he is indicating that the remaining 1,000 processed applications, certainly he's talking about, within the month that they are going to be cleared. So what's the road ahead of us? Well, he asked people for, and this is becoming less relevant, but in the whole application process, was that he was asking people for additional information, and I know people who hadn't their licence were getting worried because they had heard some people had them. We're starting to form an opinion in their head that they weren't going to get a licence, and that's not true, and I'm reassuring you of that now. There is not a problem with getting your licence. There was a request for additional information. A lot of the frustration that we all had in the last year was driven by the executive itself, and it's important here to distinguish the executive making statements. Yes, I mean they're a very important part of the process, but the executive isn't the authority, and the executive was indicating, using terminology, that they would be refusing licences, and there is a statutory process. So if there are statutory wrongs in this, there are also statutory rights. So there is a requirement, and this you would have heard me speaking to you individually about the fact of the importance of the 14-day notice of refusal, because they can't refuse your licence without you making one further written submission. So members who received a notice of refusal, I would have always drawn their attention to the fact that they did have an opportunity to make a written representation, and was important. And it is only the authority itself, the board, as opposed to the executive, have the right to refuse your licence. And no member of the society was refused a licence, and no one is close to being refused a licence. So, and even if you were, which you're not, there is a further written appeal process, and there is an appeal board, and certainly the fact that as chartered surveyors are recognised now under the discretionary powers of the authority, I cannot understand that there would be a decision to uphold that decision to refuse a licence. And this brings us to the question mark and where we are today. And I left the question mark when I was updating this presentation over the weekend, because I'm certainly confused. So I'll just share my confusion, and hopefully we'll have better questions as opposed to actually answers. So the legislation clearly states that from 6 weeks before the expiry of your licence, so I was working to a date of the 5th of July, and if you take 6 weeks from that, it brings you back to the 26th of May, which is Sunday, so bring it back to working with respect to Friday the 24th of May. So your licence renewal application has to be with the authority and finished for the Friday the 25th of May. So how is that going to happen? And there certainly is a sense of deja vu of here we go again. So the PSRA is going to issue you with a pre-populated form. In other words, it's going to give you your application form that you filled back last year finished. So it gives you back and it asks you, are there any changes in the form? In other words, this is the information we have about your company, this is the information we have about your employees, this is the information we have about your PI, etc., etc. Is there anything different? The fee for the compensation fund and the application form will now be combined. That was just a legal technical issue. You can't collect money in trust, which is the compensation fund, until you award the license. So that's why the fee was split this year. So the fee between the application, the renewal fee, and the compensation fund will be combined. So you confirm that your application form is correct. You attach the check. You will be always required to always give an updated certificate of incorporation or registration of the business name, because there's always a requirement that the confirmation, even though the certificate of incorporation may be decades old, there's always a requirement that there's a confirmation that it's within 4 weeks. So if you've relied on a certificate of incorporation or registration of business name, you will have to attach a new confirmation that that remains in place. We're told that if your PI is still, that you've previously submitted to the authority, if that is still in time, you don't need to attach new PI cover. That there will be a mechanism during the year when your PI does expire, they will write to you to look for your new PI cover. And similarly, if your tax clearance is in place and in time, again, they won't write to you until it times out. So to quote the regulator, it's been a very difficult experience for everybody, but the renewal process will become very short. So that's certainly. Now, I certainly got confused because, and I don't know whether you want to do it now, is certainly the regulator indicated that it was 6 weeks before your license was issued, and certainly people in the room in Navan last week had licenses that were issued dated October. So certainly I was working on 5,000 in the 5th of July, where certainly the 2 licenses that I saw in Navan on Thursday were October. So those 2 people were saying, well, this renewal process isn't applicable to me 6 weeks before October. And the regulator confirmed that yes, that would be the case. So I certainly asked the question as to what percentage of the 5,000 and where was the timeline. And certainly the answer wasn't clear on that issue either. So what's next? The code of practice. Certainly I think my next PSRA update will be you'll have your license renewed, and certainly I'd like a lot more information on the whole code of practice. The whole issue of the internal complaints handling procedure, the redress that the legislation speaks about, like clarity on that. Again, what investigations the PSRA are going to undertake. Again, the pendulum is swinging on that one. If a member of the general public make a complaint, the PSRA are going to fully investigate it, but they're going to suggest to a member of the general public that they use an internal complaint handling procedure and use the complaint handling procedure of the society. But yet at the same time, the PSRA are going to investigate it. To me, that's just doing 3 things when you should be doing 1 thing. So again, the form of mediation that's used and the threat of sanctions that's constantly being made against the membership. Okay, it's grand for regulators to say I have teeth. That's fine, I have no difficulty with that. But with power comes responsibilities, and you can't go around frightening people. You can be emotive and say threatening people. There is a public mandate there to inform the general public, to inform the licence holders, and where there are difficulties to and not just be threatening people with sanctions. I've spoken at length about the accountant's process and report again. If we are talking about the Friday the 24th of May, if your accountant hasn't even seen the process or the form that he has to sign yet, if it's unclear what the accounting period is, certainly that's information that we need, and I've addressed the CPD already. BER Advertising Guidelines, just to update you on that. Just the questions that were asked on the BER Advertising Guidelines was, were they, one of the main queries was, were they applicable to commercial property? Because there was some terminology around residential. They're applicable to all properties, both commercial and residential. The issue of enforcement, how, was everybody going to be in jail first week afterwards? No, that's not the case. They're very much, they wanted to raise the profile of energy efficiency in buildings. The way they're going about it, we're in discussions with them. But the aspect of it is there a soft launch with the guidelines? Yes, there is. Will there be a more rigorous regime if we don't cooperate? Yes, there will be. But at the moment, it's very much soft launch. The whole issues of incorporating the BER requirements on websites, mobile phone applications, etc. Similarly, the issue of the information that appears on signboards and in the print media and the associated advertising costs. Certainly that has been the subject of a submission to the department and the SCSI, and I know that we continue to wait for feedback on those issues. As I said, I'll take any questions from the floor, and I'm also available to take questions outside this forum if people wish to do so.
You haven't got a license yet. Are you still expected to renew it, or what are you expecting?
If you had a license previously?
No, this is all working as the license.
Sure, yeah, and that's what I meant. If you had a license, and that's what I meant. And I appreciate I wasn't clear in my question. If you were, so the issue is under section 94 and 96 of the Act. If you were providing the property service up to the 5th of July, and you applied on the 5th of July, and being really dramatic about it, it's almost as even if you sign the application form, you qualify under the transitional arrangements until they come back and tell you to stop trading. Now, have letters come back to tell people they've stopped trading? Yes, they have. But I've also pointed out that that's because of a misunderstanding by the PSRA. Somebody was qualified to provide the service before the 5th of July, had their application on the 5th of July, and there was some misunderstanding by the PSRA as to what that meant.
Yeah, because the only thing I got back from it was they said I hadn't applied for something without the night to back clear that I acknowledged that I had applied for it.
Sure. He tells me that there are 800 applications came in after the 5th of July. But he's treating them that they fall under the transitional arrangements. Now, if you wanted to be strict about it, they can't. But at the same time, he's seeing it as an anomaly in the system. So he's certainly applying transitional arrangements in this first year of licensing. So the answer to your question is, you qualify under transitional arrangements.
On the TOE, the Statement of Advised Minimum Value, is it the case that you have to be within a 10% range?
Yes.
Yes. Definitely.
And the answer that he gave to Nav and Dan last week was that it's a political legacy.
Okay.
And advised minimum value was this whole thing of, and it's quite clear that it's a political one, and this whole mess, and like you get it like I do, that we're all sleeping under a big, suitcase of cash under our beds that we managed to get to tie your ears, was the whole issue of people were so reckless is probably a very dramatic word, but certainly, the whole issue of advertising property lower than it was going to sell for and advertising it higher than it was going to, etc., etc. And that is the whole issue. And are they going to enforce the advised minimum? Yes, they are. They're going to see it, that they want it. The regulator clearly wants to be able to see that there was a realistic valuation market valuation put on a property, and that if somebody was playing games around that, he wants to be able to see it. And the ultimate one is if you advertise a property for less than the advertised minimum value, that is a very, very serious issue.
And how then do the likes of Alsops, how do they deal with that if it's the case, because they do promote low guides for auction?
Are they required to, under their letter of engagement, give advised minimum value?
Why wouldn't they?
Yes, no, you're correct as you're saying it. I was just thinking, yes. So,
it's just clients would ask, obviously,
yes.
that the guides are low. You know,
Well-
could we not go with the low guide to attract interest?
Yeah.
X, Y is doing it.
Well, let's pick them off, right? So the letter of engagement is clear. You're advised it's either a figure or a range of figures, and the range of figures must be in 10% of each other. There is a facility under the letter of engagement to change the advised minimum value. So that's your discussions with your client.
And what do you mean a facility to change
You
during
can
the
change,
process?
yes,
Okay.
you can like, if the letter of engagement is a contract between two parties can renegotiate a change to that contract. So similarly, if the advised minimum value needs to change, now this is where I see difficulties in lab practitioner coming in, where the client then starts dictating that there should be a different advised minimum value, and that's one that's rattling around in my head at the moment. And then can somebody check the register to see the locality? In other words, but let's just keep breaking it down. So you set your advised minimum value. There's a facility to change the advised minimum value. Certainly as a practitioner, I'd be very careful about changing it because of being influenced by the client telling me to change it. But I think you all know that in this room anyway. Then the issue then of the client then saying what they want it advertised at. So the Act expressly states that you cannot advertise the property less than the advised minimum value. And the regulator is indicating that if you are advertising less than the advised minimum value, that you're in breach of the Act, and that it leads back to similarly, if the client says, well, I take my business down the street, he's saying, well, get that client to come and talk to me. I expect that they can't auction their property. The specific examples of the commercial entity that you named, I'm not aware, and in fairness I haven't looked either, but certainly I'm quite clear that you cannot advertise less than the advised minimum value. And if they are doing so, if that commercial entity is doing so, they are in breach of the Act. Just conscious that there's another speaker coming after me, so as again, I just throw that offer again that I'm not running away. I'm here for the day, and if anybody wants to speak to me one-on-one in any forum, I'm happy to do so. Thank you very much.